All right, you're Ava Musgrove.
Yes, Your Honor.
And in cause number 25, DCCR 0048, Ms. Musgrove is charged with the first degree felony offense of murder. And that's from December 29th of 2024. And what that means, ma'am, and we've gone over this before, is that if you go to trial and you're found guilty, the range of punishment would be between 5 years and up to 99 years or life in prison. Do you understand?
Yes, Your Honor.
And I have a plea bargain rejection that you've signed here today with Mr. Gertz that shows that the district attorney's office has made an offer if you wanted to enter a plea of guilty for a cap of 30 years in prison, which means you would be leaving your punishment up to me. I could give you 30 years. I could give you less. It would depend on any information that was brought to me at a sentencing hearing. You have every right to reject that and have your case set for trial. I just want to make sure you understand possible consequences if we go to trial and what your options are. And do you understand all of that?
Yes, Your Honor.
And do you want to reject that offer and have your case set for trial?
Yes, Your Honor.
All right. And so based on kind of some of this back and forth, is there any reason to believe anything would change with regard to that offer?
No, Your Honor.
So I want to make everyone, make sure everybody's clear that there will not be a plea. This plea agreement will not be accepted after today. So it's either trial or a plea to something different unless there's some new evidence that's discovered that you guys don't have for some reason at this point. Do you understand?
Yes, Your Honor.
Right. And as far as you know, everything's, you have all the discovery and,
As far as I know.
okay,
of all the
any,
stuff,
you're not waiting on anything?
No, I don't know of anything that's still out there.
Okay, we'll get it set on the next available trial docket. You can go back with the bailiff. Okay. Good morning, you're Giovanni Coleman. And this is 25 DCCR 0479. Mr. Coleman's charged with murder. Mr. Gertz, what is the announcement?
Judge, we're going to ask for one additional resetting. There's a number of reports and videos in this case that involves, I would say, pretty hyper-technical cell phone and block evidence. So block evidence is photographic evidence. Okay, sorry.
Thank you.
Sorry. Is this your first day?
It's not
my first day.
It's not my first day, but I appreciate that.
I apologize.
That's okay.
I'm so sorry. Either way, that a lot of the mapping and location and work that was done here just needs some additional review, in my opinion. And then we were able to find very recently a ballistics report that was not labeled ballistics report. It was labeled like F-25 and didn't have any content. And so anyway.
So I'm gonna do one more. It looks like you have been on since May 2nd. So it's getting time for an announcement. I'll do another reset, but we need to see if we could get an announcement at that next court day.
Okay.
Okay.
Good. Thank you, Judge.
Stay in touch. He'll stay in touch with you. Good morning, sir. You're Raymond Sweet.
Yes, ma'am.
And this is 25 DCCR 1531. Mr. Sweet is charged with burglary of a habitation with the intention to commit a felony. And what is the announcement?
Your Honor, could we ask for another announcement date on this? There's a good bit of visual discovery that I haven't shared with Mr. Sweet.
And it looks like you were
I think this
in
is
December. So I'll do one more reset to give you some time to go out and go through all of that with Mr. Sweet, and then we'll get an announcement at the next court date.
Thank you.
All right, thank you. Mr. Vasquez will be out to the jail to go over all the evidence with you, and then we'll get an announcement at the next court date.
All right, thank you.
All right.
I have something I want to give to
You can go back with bailiff. He'll come back there. All right, are you Willie Pugh?
Yes, ma'am.
And this is 25 DCCR 1835. Mr. Pugh's charged with unlawful possession of a firearm by felon. Mr. Pugh, Mr. Rojas has let me know that you or your family are trying to hire a lawyer. Is that correct?
Yes.
So are you asking me to reset your case a little bit to let y'all do that?
Yes.
So what I'm going to do is about a 30-day reset, which is a normal reset. If y'all get someone hired, they'll do the paperwork to substitute in. If for some reason you're unable to hire someone, Mr. Rojas is still your attorney, will remain on your case. And when we come back at that 30 days, if you haven't been able to get one, then we'll need to move forward with Mr. Rojas, okay?
Yes, ma'am.
All right, you can go back with the bailiff. Thank you, Mr. Rojas.
Thank you.
All right, sir, are you Christian Lazo?
Yes.
Yes. And will your client waive the formal reading of the indictment?
He does.
Mr. Lazo, in clause number 25, DCCR 1423, you're charged with the first degree felony of aggravated robbery from May 25th of 2025. And how do you plead to that charge?
Guilty.
Are you pleading guilty freely and voluntarily?
Yes.
And are you pleading guilty because you actually did what they charged you with?
Yes.
I have here on this tablet some documents that have your signature on them that the state's marked as exhibit number 1. Before you sign these, did you go over them with your attorney, with the interpreter?
Yes.
Do you fully understand them?
Entiendo el papeleo que le explicamos.
Sí.
Yes.
And do you understand if I follow the agreement that you've made with the district attorney, that you'll be waiving or giving up any right to appeal?
Una apelación en su caso.
Sí.
Yes.
And it looks like the agreement that you've reached is for a cap of 15 years in prison,
Es de no más de 15 años en la prisión.
which means that you're leaving your punishment up to me.
Sin que yo deba de hacer la decisión de su sentencia.
And as long as I give you 15 years or less,
Es que yo le dé 15 años o menos.
you're giving up that right to appeal. Do you
No va a
understand?
poder apelar. ¿Sí entiende?
Sí.
Yes.
You have an absolute right to have a
Sí, tiene
jury
un
come
derecho.
determine 2 things.
De pelear un juicio y que vengan a determinar dos diferentes cosas.
The first would be to
La
determine if you're
primera
guilty or not.
Que ellos determinen si es culpable o no.
And then you could leave your punishment up to that jury if
Y
they
lo
found
que
you guilty.
el Jurado y lo encuentre culpable.
And if we go forward this way, you're waiving that right.
Pero si se
And is
ven
that
de
what you
esta
want to
manera,
do?
dice, entonces no va a poder tener un jurado y yo soy la que debería pensar.
Sí.
¿Sí entiende?
Sí.
Yes.
Do you also understand if you're not a US
Que si no
citizen,
es ciudadano
that
americano,
a plea of guilty or no contest,
que
may
de
result
plano
in
se
your
culpable,
deportation,
puede resultar en una deportación,
exclusion from admission to the
sin volver a
country,
poder entrar al país,
or denial of naturalization under federal law?
negar que pueda recibir sus papeles.
Sí.
Yes.
State tenders number 1,
No objection to it.
it's admitted. Is there any evidence that Mr. Lazo is not competent?
No, dude.
Sí, hay evidencia que usted no-
All right, sir, I'm going to find that you entered your plea of guilty freely and voluntarily.
Declarando culpablemente por su propio
Find
decisión.
that you're mentally competent and understand the nature and the consequences of that
Entiende
plea.
lo que está pasando.
Find sufficient evidence to
Y
find
que
you
se presente
guilty.
evidencia de encontrarlo culpable.
However, I'm going to reset your case so that the probation department can do a pre-sentence report.
Condicional vaya y algún reporte
And that'll give you more information, give me more information about you and your case.
sobre usted y su caso.
And then we'll come back later for
Luego,
sentencing.
Vamos a venir a sentencia.
Anything that you think is important for me to know,
Cualquier cosa que usted piense que es importante.
get that
que ella
information to
sepa,
Mr. Lewis,
pase la
and
información
he'll present it to me
sobre
on your
ella,
behalf when we
y
come
él me
back.
lo va a presentar cuando regresemos. Okay.
Thank you very much.
Okay.
Thank you, Ms. Burge. And if you'll
Thank you,
just
Judge.
real quick, I think probation is probably gonna hand them a piece of paper if you'll just make sure you
Yes,
just
ma'am.
do that. Good morning. Are you Marco Gomez? Speak up, please. And this is case number 21-36-534. And Mr. Gomez is charged with sexual assault, set for trial to begin with jury selection on Monday, the 23rd. And what is the announcement?
Ready. Stay true.
All right, obviously, this is one of the oldest ones we've got, and so I would anticipate that it would be pretty high on the list, if not the top. Is there anything that you guys need me to know or we need to discuss before I number those cases today?
No.
All right, it looks like there was a previous rejection back in November. No changes or to that. That was for 15 years.
That was the offer we rejected, Judge. We had actually signed paperwork this morning for 8. After we signed it, I think the complaining witness called Mr. Smith and expressed that she did not want the 8-year offer. And so that was withdrawn. So
Okay.
we're here back at the trial docket.
All right, so then I'll set it. There won't be any plea agreements after today. Mr. Gomez, if you change your mind and want to enter a plea of guilty, it would be open to the court or to some other number other than that 15. Is that where y'all are at 15?
That's where we're at, Judge.
Okay, all right, then I'll set it and we'll probably see y'all at 1 o'clock on the 23rd. You can go back with the bailiff.
She is the mother of my youngest son, as well as we were married for 15 years.
And when did you say were married? When did the two of you divorce?
The exact date I couldn't tell you, sir. Approximately 4 years ago.
And do you recognize the individual here in the orange jumpsuit?
Yes, I do.
Who do you know him to be?
Shay Allen Merchant.
And let's just cut to the chase. What has been the nature of your involvement or interaction with Shay Merchant?
It has been very stressful and threats provided by Mr. Merchant.
Threats directed toward
Directly towards myself and my 9-year-old son.
And back on December the 10th of 2021, did you have an occasion to speak with the defendant on the telephone?
Yes, sir. I received a phone call approximately 5:30 to 6 a.m. In the morning.
And during that phone conversation, what, if anything, did he say to you?
During the original phone call conversation was several threats provided to myself by Mr. Merchant.
And after that initial call from him, did you call, did you call anyone?
Yes, sir. Once the phone call disconnected, I turned around and called my ex-wife to inform her of what was taking place.
Did she answer the phone?
No, sir, she did not.
Who answered the phone?
Shay Merchant answered the phone.
And how did that call go?
Started by yelling, screaming, and threats by Mr. Merchant with continuous threats, not only towards myself as well as towards my 9-year-old son.
Was that, did you record that phone call?
Yes, sir, I did.
I'm handing you what's been marked State's Exhibit number 3. Do you recognize that?
Yes, sir, I do. It's the CD that has the recording on it.
The recorded phone call from December the 10th of 2021 between you and the defendant.
Yes, sir, that is correct.
You've listened to this recording. Is it a fair and accurate recording?
Yes, sir, it's very accurate.
Made by a device, your cell phone, that was capable of making an accurate recording?
Yes, sir, that is correct.
And you certainly knew how to properly operate your cell phone, correct?
Yes, sir.
Now, at this time, I'd offer States 3.
I'm going to object that has not been provided to the defense. We have requested discovery and we have not received any recordings from the state. So we reset this hearing to provide Mr. Cole the opportunity to bring witnesses forward, and objecting to him presenting an audio recording, something that it's not been provided to us and we've not had the opportunity to review.
Judge, I only received this recording within the last day or so.
Okay.
That's fine. So, well, and the testimony as far as what kind of went on back then, I'll take that, but I'll sustain the objection.
During the phone call, did the defendant make derogatory statements about you or your family members?
Yes, sir. Against myself as well as my 9-year-old son.
What did he call your 9-year-old?
He called my 9-year-old son retarded.
Did he threaten to kill you?
Yes, sir.
Was this the only instance of any threats or harassment by this defendant toward you?
No, sir. The following Saturday, when I met Tammy to pick up my son in the Hobby Lobby parking lot, Mr. Merchant got out of the vehicle and started to attack me. Tammy and a law enforcement officer had to pull him off of me.
Did you file charges as it relates with the law enforcement as it relates to the threats that were made on the phone call?
Yes, sir, I did.
Ultimately, did you file what's referred to as a non-prosecution affidavit?
Yes, sir, I did.
Why did you do that?
I did that after talking with Tammy and her expressing the stress and hardship that it was putting on her household, as well as the stress on my 9-year-old son in that household. I felt that to relieve the stress and the tension and violence within that household, to drop the prosecution of it, hoping that it would help relieve the situation that was within the household.
And the fact that you filed that non-prosecution affidavit doesn't in any way negate or indicate that what you testified to that had transpired actually.
That is correct. That is correct, sir.
Are you concerned about the safety of your? Are you concerned?
Yes, sir. I'm very concerned. Not only am I concerned for Tammy, as well as my 9-year-old son and my 18-year-old stepson that lives in the household.
And you understand we're here today on the bond reduction. The defense counsel is asking you to consider lowering this defendant's $250,000 bond. What would you like for the judge to consider or know with it in that regard?
I would like you to know the fact that since Mr. Merchant has been locked up, there has been several threats exchanged, as well as violation of the protective order for my two boys, as well as Tammy, by not only literature communication, phone communication, as well as communication from family members that he has had to contact my ex-wife. The mail correspondence is still taking place, and it violates the 5-year protective order that the judge has signed and put in place.
That's all I have, Judge. Thank you.
All right, Mr.
So just a few questions. First of all, you have expressed to the court that you have concerns about your safety related to Mr. Merchant, correct?
That is correct.
Of course, you also testified to that he allegedly committed a crime against you, correct?
That is correct.
And you also informed the court that you were so concerned you filed an affidavit of non-prosecution. Is that correct?
That is correct.
Okay. And you've also taken upon yourself to contact various bond companies and things of that nature, basically to slander my client. Is that correct?
Contacting, correct. Slander? No, sir.
Were you calling to talk about what a wonderful human being he was when you called him?
I was calling to prevent him from bombing another jail.
Okay, so my question is, so you were calling basically to defame my client, to slander his name to various bond companies that did not contact you. Is that correct?
Sir, slander is stating something that is not correct. I stated what is correct.
If we're going to play semantics thing, but I can do that all day.
All right, no, we're not going to go there. Just, he's answered the question.
Okay.
Ask another question.
All right, I'll pass the witness.
All
I
right.
have nothing further for this witness, Your Honor.
All right. Thank you, sir, for coming. You can sit
Thank you,
down. All
Judge.
Your Honor, I briefly called Troy Robinson to the stand.
right, Mr. Robinson.
Of someone with at a minimum anger issues and at most issues with violence. We also have the ingredient of some very serious allegations here. Brandishing a firearm, holding a knife to someone's throat and threatening to kill them. And lastly, the last ingredient to this is, Judge, we've got a defendant who, even from the jail with a pending protective order, is violating that order. He's demonstrated a lack of respect for the law, a lack of respect for court order. Judge, all those ingredients, they are a recipe for something tragic to happen. And this court, under the Code of Criminal Procedure, can consider the public safety as one of those factors in setting a reasonable bond. And the state's position is that a 6-figure bond in this case is not unreasonable. We'd ask that the court deny the defense motion to decrease or to reduce the defendant's bond for those reasons, Your Honor. Thank you.
Anything else?
No, Your Honor.
So based on all of the evidence that was presented today, as well as, I don't know if everybody, y'all all know me and y'all know what I do during these hearings, and I typically keep my eyes on the defendant, the facial expressions, the attitude of Mr. Merchant, I believe is absolutely in line with what Mr. Coleman has said. I'm going to deny that writ or deny that. The bond, I think, is appropriate at what it's set at. We'll get this set for an announcement and we'll see where the case goes. Thank you. Y'all are excused. Was this on a writ to you?
And there it is, a decision that will echo far beyond the walls of this courtroom. Ava Musgrove chose her path, fully aware of the stakes. Years, decades, even a lifetime hung in the balance. Justice doesn't pause, it doesn't wait, and today, it reminded us how heavy choice can feel. Every signature, every plea rejected, every moment of clarity in that room holds weight, because behind each case are lives forever changed. In the end, it's not just about guilt or innocence, it's about accountability, courage, and the consequences we all must face. What would you do if the decision were yours?